Ms. Williams, you're here for case management on one count of driving while license suspended, resisting or obstructing officer without violence, and failure to register a motor vehicle. My understanding is that you do not have an attorney presently, and I think I received a number of filings that you filed 4 filings this morning with the clerk of court. I had a chance to briefly review them. So before we proceed, would you like to have an attorney appointed to represent you?
I represent myself.
Okay, so we'll address that in a moment. Mr. Helling, I think that I saw that Judge Bishop had notes in this case about having this case set for trial if there's no movement in this case, because I understand, Ms. Williams, you don't intend on entering a plea.
I'm sorry, I'm 75% deaf. I almost didn't hear any of that.
Sure, so I'll try to speak a little bit louder. Ms. Williams, my intent today is to set this case for a trial.
You're going to address the jurisdiction challenge?
Yeah, it's legally insufficient. It's denied. We have personal jurisdiction over you because you live in the state of Florida and you were operating allegedly a motor vehicle on the streets or highways of Union County. So we have personal jurisdiction over you. That's going to bring me to the next point, which is you indicated that you're pro se and that you do not intend on hiring or having an attorney represent you. Is that correct?
From this point on, I'm invoking constitutional law in this courtroom.
Okay, I intend to follow the U.S. and Florida Constitution, so we're on good standing.
And reserve all of my rights. And at this moment, I'm going to choose to invoke my right to remain silent. And because it's a criminal court, my silence cannot be construed as consent or guilt.
Okay, so here's what I'm going to do is I'm going to ask you some questions about whether or not you understand how to represent yourself. If you choose to remain silent, I will appoint an attorney because you've refused to answer my questions.
I reject that.
Okay.
I object. Excuse me.
All right. So have you ever studied law?
Yes, for the last 4 years.
Have you ever represented yourself in a criminal action before?
I know, I stay out of trouble.
So is that no?
No, I never, does that matter?
It does, because it goes to your knowledge and ability to represent yourself as well as to understand and appreciate.
I'm very competent. I'm not to be presumed ignorant.
Okay. Do you understand each of the charges against you?
No, I do not.
Okay. So you are charged with one count of driving while license is suspended or revoked, which means...
What was the probable cause to pull me over?
So that's not what I'm asking you right now.
That has to be put on the record before any proceedings.
Okay, well,
by law.
So you were charged with driving while your license was suspended or revoked.
I wasn't driving. I was wrongly accused.
Buckle up, guys. Today, we are diving into one of the most chaotic courtroom encounters you'll ever witness. Right from the start, the narrator sets the tone by introducing a woman who somehow manages to invoke her right to remain silent while constantly talking over everyone around her. Before the courtroom madness begins, we get a quick setup that hints this case only gets crazier with every hearing. And trust me, this intro perfectly prepares you for the absolute train wreck ahead.
Try your case. This is for me to decide whether or not you're competent to represent yourself at trial. Okay?
I am.
Well, I will make that decision. So you are charged with one count of driving while license suspended, one count of resisting an officer without violence, and one count of failure to register a motor vehicle. Do you know the maximum penalty for each charge?
No, I don't.
Are you familiar with the legal elements of each charge?
No, I don't recognize policy. I don't recognize
not my question, which
administrative law or statutory law.
Well, you may not recognize it, but it will be imposed on you, and if you are found guilty, the judge will impose a sentence whether or not you recognize it or not. Do you understand that?
If you force jurisdiction where there is none, you'll be open doors to impeachment and lawsuits.
Okay. Well, I probably won't be the judge trying the case, so that's okay with me.
Your Honor, if I may, I think that Judge Bishop has gone over these with her already, and she has once again maintained her
Sure.
proceed pro se.
I think though, if I'm setting for trial, I think just to be safe for every stage, I'm just going to go over.
I'm going to say this is case management. It will go to pretrial next month, and then trial after that. So I think we're one step away for setting it full trial.
I'm going to fire any judge, any attorney that's been appointed to me. So.
Well, so I guess, Mr. Salter, if I set this for trial, would you be willing to be standby counsel just in case?
I think I would need to be, yes, sir.
Yes.
He's fired.
Well, you don't get a fire, you're standby counsel.
I do not consent to that.
Well, that's the thing about this is that
I have a right to represent myself. I've made it clear.
You have the right to represent yourself.
Yes.
But also the other part is that you have to be fully aware of all the risks that come with it.
I am. I'm willing to take any risks.
Okay. I'll just put it this way, having read your legal filings as well as the arrest report, I think you fundamentally misunderstand the laws and Constitution.
I am not. The Amish community has well kept up that right.
I'll just put it this way, I don't see many Amish people driving cars and using phones.
All right, guys, now the actual courtroom drama begins. The judge calmly explains the charges, including driving with a suspended license and resisting an officer. But things quickly take a bizarre turn when she announces she's representing herself. Instead of answering simple legal questions, she suddenly starts invoking constitutional rights and claims her silence can't be used against her. The judge remains patient here, but you can already see this hearing heading straight into chaos.
For the next month,
Judge Bishop. When is our pretrial conference?
June 10th.
All right. So it's the same day as case management?
Yes, Your Honor. We only have one misdemeanor court date.
All right. So I'll put your case on for pretrial conference. Be aware that you are charged with driving while license suspended and resisting an officer. Both of those are first-degree misdemeanors. Maximum punishment of those consecutively would be up to 2 years in the county jail. Failure to register a motor vehicle, that's a second-degree misdemeanor, which is punishable after 60 days in jail. So you could find yourself spending up to 2 years and 60 days in jail on these charges. Do you understand that?
No, I don't. But
okay. So here's what happens is if you're found guilty, because what the state's required to prove are the essential elements of each charge.
I have all that.
The essential elements of driving while license suspended is that you were operating a motor vehicle on the streets or highways of Florida while your license or privilege was revoked or suspended.
I still don't
Whether or not you were
cause.
traveling, flying, or whatever you want to describe it, if you were in a car and that car was moving and you were operating that car and your license was suspended, then the jury would be instructed that all essential elements have been proven and they should find you guilty. Likewise, resisting an officer means that you resisted, obstructed, opposed an officer in the lawful execution of a duty, but you did not offer violence during that. If they find that you committed that offense, you would be found guilty and could be punished by up to a year in the county jail. So with that, you wish to have this set for trial?
No, I do not.
Okay.
But I wish to have it dismissed.
Your options today are to enter a plea or set it for trial.
You make the call.
Okay.
I'm not going with any plea, so.
Okay, then we'll set it for trial. So that's how the case will be resolved. We'll set you on for June 10th for pretrial conference. Please sign notice and we'll see you then.
Thank you.
Now things start getting ridiculous fast. The judge is simply trying to determine whether she's competent enough to represent herself. But she keeps interrupting, dodging questions, and challenging basic courtroom procedures. She refuses to acknowledge the charges properly and keeps shifting the conversation toward her traffic stop. You can feel the judge trying to stay professional while realizing the situation is becoming much harder than it should be.
Article 6, Clause 2 of the United States Constitution says, "This Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land, and the judges in every state shall be bound thereby, and anything in the Constitution or laws of any state to the contrary notwithstanding." This means no state law, no local ordinance, and no traffic code can override the the supreme authority of the United States Constitution, especially when it comes to the fundamental liberties of the people. I am here today as a special appearance, not because I committed a crime, but because I exercise a federally protected, clearly established constitutional right, which is the 14th Amendment right to travel in my private automobile without government permission or interference.
All right, stop. I don't have time to deal with this, and I'm not going to listen to this. Everything you're saying is absolute nonsense.
No, it's very true.
Stop talking. Don't talk. Everything you read about, when you read from the Constitution, yes, you read that correctly. Your interpretation and everything you think you're doing is absolutely wrong. The writ of prohibition that you filed in the First District Court of Appeal was dismissed yesterday, and we received that order, okay? I don't know what you think you're going to get by filing a writ of prohibition in the United States Supreme Court. If they even choose to answer that, we'll wait to see if there's an answer to that.
I will.
All of your claims are absolute nonsense, and I don't have time to deal with them. You were charged with driving on a suspended license, resisting an officer without violence, and failure to register a motor vehicle. Stop. Don't talk. The state attorneys offer to you as an adjudication of guilt a $100 fine, court cost, and cost of prosecution.
Judge, to clarify that offer is no longer open.
That was the offer, okay? So there you go. The state attorney revoked.
This is where things become completely unbelievable. She suddenly starts pushing bizarre arguments about travel rights and even drags Amish references into the conversation while facing actual criminal charges. Meanwhile, the judge breaks down the serious penalties she could face, including jail time, but she still refuses to make things easier for herself. Instead of helping her case, she keeps digging herself deeper into legal trouble.
Just don't. I have to end our docket today because I have another appointment to get to go through a Feretta hearing with you right now. But you have indicated previously that you want to represent yourself, and so far you have been representing yourself, and with that being all the state had previously been asking for, that's all we would have done anyway. Okay. So you're not going to like anything I'm going to do right now, okay? And you're probably not going to agree with it. If you want to file all the nonsense that you've written down on paper and file it with the clerk, you certainly can. And then you can appeal any decision that I make to determine whether or not I've acted within the laws of the state of Florida, okay? I'm going to temporarily, because I expect that you're probably going to want to represent yourself if that's what you want to do, but you do have the right to have a lawyer represent you, and it sounds like the state's going to turn a little harder toward a more severe punishment. I'm going to appoint Mr. Salter to represent you today. I want you to at least try to have a conversation with him. And if you don't do that, well, we'll deal with that later. I'm going to continue the pretrial conference to the July docket. And at that date, if you indicate to me that you want to represent yourself, then we'll have a Feretta hearing on that date.
That's fair.
I'm not going to hear anything else from you today. I don't have time to deal with it.
I understand.
If there's something that you want to file, you can write until your hand bleeds on your paper. You certainly are free to do that, and you can file it. Whether it has any merit or not, I'll make decisions that I have jurisdiction to make, and then the appellate courts can make decisions about the jurisdiction, about the things they have jurisdiction to make, to include my decisions and my legal opinions, okay? I'm not going to deal with all of this today, all right? Sign your notice to appear for July 15th, and I'm appointing Mr. Salter to represent you for today.
All right, we've now entered round 2, and somehow things get even worse. She walks into court prepared with constitutional speeches and starts claiming no traffic law can override her rights. The judge wastes absolutely no time shutting that argument down and calls her claims complete nonsense. To make things worse, the plea deal that could have saved her disappears right in front of her eyes, and the pressure instantly rises.
Okay, we've had many conversations here on the record, and that hasn't been an issue before, but I'll do my best to speak up.
Because you screamed at me last month, so, I didn't have no problem hearing that. So, yeah, okay.
Ms. Williams, I didn't scream at you. Everybody in the world has seen the video you posted of our court proceeding
Yep.
here, okay, to include myself.
Only 600 something.
That's great. I have no problem with anything that I said in your case, so you do what you feel like you want to do.
The JQC had a problem with it.
It does appear, and I will say that it does appear that you properly requested through a public records request to get the recording of what we do here in court.
Yeah, I did.
And that's
Paid
what you
for it and
published.
everything.
I want to caution you and anyone who's with you that if you privately record anything in this
I ain't
court,
privately recording anything.
let me finish talking. Stop interrupting
just
me.
proving it.
Because
Sorry.
you need to hear this. If you privately record anything in this courtroom, then you'll be in violation of the administrative order that prohibits such recordings, and I will proceed with contempt
That's fine.
proceedings. Do you
As
understand?
long as they work, I'm good.
That camera's working, that camera's working, everything's being recorded. You request away under Chapter 119 for all the public records you want. I have no problem with anything I say here on the record, okay? All right, I understand all of the things that you filed. I want to make it clear for the record that there are several things that you filed that I have determined are not legally cognizable.
Some of them were just, just letters not
Sure.
meant to be.
Okay,
So,
I
yeah.
have stricken those things that I found to be legally not legally
What exactly
incognizable,
are
okay?
those things?
Again, you know how to do a public records request, so you can request your court file and get a copy
They get
of the
ignored.
things, okay? Stop interrupting me when I'm talking, all right? I entered an order striking several of the pleadings. You did file one where you objected to the forced appointment of the public defender. And that, I believe, does legally trigger a Ferretta hearing. And so I did set today to have a Ferretta hearing with you, to go through the colloquy with you, to allow you to represent yourself if I find that you're doing that knowingly, intelligently, and voluntarily. Do you understand that?
We first have to establish jurisdiction on the record before we can do that.
No, jurisdiction is, I do not have to go, that's the.
You have to have both jurisdictions before you can proceed. You don't have either one of them. Neither one of them have been proven on the record.
All right. What is it that you think? I'm going to entertain
I
this for just a
already
minute.
said them
What
to
is-
you,
What is
so-
it that you think? Well, say
I have a whole
say
list.
it here on the record. What is it that you think compromises this court's jurisdiction right now?
Is constitutional violations. This court clearly does not honor the Constitution, so therefore it's not a federal court. It needs to be moved to a federal court because my rights were violated from the start.
Your charge
The
of-
initial traffic stop was unlawful.
Your charge of driving on a suspended license, resisting an officer without violence, and failing to register a motor vehicle, all violations of Florida statute, you say
Florida
belong-
statute.
You say
I was
belongs-
exercising federal protected
Okay.
rights that
this is-
Florida
this
has
is-
to honor
Ms.
as well.
Ms. Williams, this is the nonsense part I'm talking about. This is what we've been through in the past, and this is, I cut you off last time simply because I didn't have time to go through this kind of dialogue.
You didn't have time
I
when you
didn't.
were on the clock.
I sure did not have
I
time to go
bet.
through
You saved my case for very last.
And look where you are now.
Yeah, now.
not last.
Trying to prove me wrong ain't proving nothing wrong.
But you should realize that actually having you go last might save you a little bit of public embarrassment, but here you are.
There ain't no
and
embarrassment.
everybody's
I'm
watching.
speaking truth, and you're silencing the truth to
All right.
keep these people from learning.
At this point, the judge's patience is clearly running thin. He explains that he doesn't have time to entertain endless legal theories and decides to appoint an attorney to help her whether she likes it or not. She continues resisting every attempt to move the case forward, while the judge makes it clear that her paperwork and arguments aren't helping. This moment feels like a major turning point in the entire case.
Let's go through the discussion about whether you represent yourself. Can we do that? And can we do that?
No,
with-
we have to discuss jurisdiction first. It has to be proven on the record before we can proceed. Otherwise, I don't consent to any proceedings before jurisdiction has been established.
As your lawyer, I can tell you.
You're not my lawyer.
If you
All right.
let the judge go through this inquiry, then I'm not your lawyer. Then I'm officially not your lawyer. Then you can make your arguments.
There ain't no argument. The only argument is this
All right.
judge does not honor our constitutional right. Doesn't honor the law.
I'm trying to go through the questions that I am required to go through under the law before you were to represent yourself.
You're required to do this too.
Okay.
We have to do this before, you don't have jurisdiction to even determine a Feretta hearing. That's why this has to be said first.
You think this needs to be in federal court and that I don't have
Yes,
jurisdiction?
my federal rights. You do not acknowledge or respect the people's right to travel in this country. Florida is in America. Our Constitution supersedes all state policies, laws, or whatever. And you're not accepting that. That's fact.
This is the part where you don't actually understand how
I do understand it.
works.
Constitution was made for the simple man to understand. It's very easy to understand. Supreme Court has made precedents even more clear for people to understand. The very many that I sent you, which is absolute clear, you're refusing to acknowledge.
I actually read through several of those cases just to double check.
They don't have to be about being pulled over for no drivers. Like, it's all protected rights.
You're citing dicta, or you're citing holdings that apply to a different application of that constitutional right. None of those holdings.
They all have.
None of those holdings said that a state cannot require licensure.
Yes, it does.
For a driver?
Yes, it does.
No, it doesn't.
I will have them
See,
when we go to trial.
I can't have this nonsense discussion.
It's
with you
not
because
nonsense.
We can't get anywhere.
You're not recognizing it as truth, so you're calling it nonsense.
Will you go through the Feretta inquiry with me? Because if you will, then we can have this. We can have this.
No,
inquiry.
that would be me giving you jurisdiction over me in this case, and I'm not going to do that.
All right.
You have to acknowledge the personal jurisdiction. I have a whole list here. We can go over each one if you want.
I want to allow you to represent yourself if you can go through those questions with me. But if you continue to be obstreperous the way
We have
you
to go
are
through
right
these
now,
first before we can go through that.
Here's the other part about court and jurisdiction is that you, Ms. Williams, as the defendant in court, do not get to tell the court how to conduct procedure in court.
A court.
And now we enter another hearing where things instantly go off track. It starts with arguments over hearing accommodations, courtroom recordings, and accusations about how previous hearings were handled. The judge warns her about recording violations while trying to keep control of the courtroom. Instead of calming down, she keeps pushing back on nearly everything said to her, creating even more tension before the biggest clash begins.
That means when you say that. Okay. You have graced us with your intelligence in all of your pleadings, and those are all a matter of record. Okay? And if I have made some decision here today and your case results in a conviction at some point in time, then the appellate court can review everything that you wrote and everything that's been said here and determine whether or not I've made a legal error. Determine whether or not
I think the JQC is going to determine that in 3 days.
I welcome anything the JQC has to say about what's going on in this case. I certainly.
How about we continue this until next month and then determine on that? Can we do that?
You don't get to. You can make a request.
That was a request. I asked. Can we do that?
Stop trying to tell this court what it's going to do. Do you understand that?
I'm being forced to be here under threat, duress, and coercion. I'm not here voluntarily.
You're giving me no.
And I'm not.
Stop talking. Now I'm going to stop you because you won't stop. I'm trying to give you a chance to speak. I'm trying to give you a chance to.
But I wasn't done.
Stop talking. Now I did raise my voice, and I did. Yes. Stop talking. If you say another word, I'm going to have a deputy escort you out of the courtroom. And I'll give you a chance to cool off, and then we'll give you a chance to come back in if you think you can behave like an adult. Okay? I'm trying to give you the chance to represent yourself. What you're saying about the court establishing jurisdiction is one of those things that is not legally cognizable. It isn't. Okay? I know you believe it is, but I'm deciding and determining here that it's not. The next order of business is that you did file a legally cognizable request to represent yourself. You did do that. And I want to give you that opportunity. I'm required to actually give you that opportunity, and I want to try to give you that opportunity. Stop talking, okay? I have to go through those questions with you in order to allow you to represent yourself. That would give you more ability to, in fact, file some of these pleadings, and I wouldn't be entering an order striking them because of dual representation. They would remain on the record, or they would be stricken as legally incognizable, but they would remain there in the record so that any other superior court can determine whether or not I made a legal error. But I can't get to any of that if we don't go through the Feretta questions. And if you continue with this obstreperous behavior, with this disruptive behavior, then I will have no choice but to require that you have a lawyer and require that you sit at counsel table during a trial and not say a word until it's your opportunity to testify in your own defense if you so choose, and you will be given that opportunity because you are entitled to that under the due process of law and under the Fifth Amendment, okay? And you also have the right to remain silent, either one. But up until that point, I will require you to sit there and let your attorney argue your case. And yes, subsequent to Feretta, there is other case law from the United States Supreme Court that says that when a defendant is disruptive in court and cannot comport themselves to proper courtroom decorum, then I do not have to let you represent yourself. I do not have to waste the people of Union County's time in a jury trial having you spout hours of nonsense to them that has nothing to do with the decision that they would have to make about whether you were guilty or not guilty of the offense that the state has charged you with. I'm going to give you one more chance. Do you want to go through the Feretta questions with me now so I can determine whether you can represent yourself?
I'm invoking my Fifth Amendment right to remain silent, and once again, my rights will not be interpreted as consent or guilt.
This might be one of the most frustrating exchanges in the entire video. She repeatedly argues that the court has no jurisdiction over her and insists the case belongs in federal court because her constitutional rights were violated. The judge carefully explains why her arguments don't hold up legally, but she refuses to listen. This becomes a non-stop battle where neither side can move forward.
And actually just cooperate with the court's procedure. Cooperating with the court's procedure has nothing to do with you admitting or denying guilt. You can say one more thing. Go.
This is not a federal court. Federal crimes were committed against me in the initial traffic stop. It took this jurisdiction right away from you. Okay. And you're forcing jurisdiction.
Your Honor, I'm asking to continue the pretrial conference one more month so that perhaps she can have what she wants from the JQC inquiry, and then we'll see where we are next month.
Absolutely. I think you said something about them meeting today, or in fact,
3 days or something.
3 days from now, yes.
3 days from now. That's great. Well, we'll see how that goes. You should try to meet with Mr. Salter. You should try. Look at that, Mr. Salter.
I just thanked him. I'm a very kind person.
Look at that. He's looking out for you. He's actually doing
Well, he did that one other time also, too, when Judge Wright was here. He did look out for me then.
What's our name?
I acknowledge that as well.
Pretrial conference has continued to August 12th. And we'll see where things are from there. At this time, you're not going to be allowed to represent yourself. I'll give you one more chance on August 12th to determine whether or not you...
Now the courtroom reaches peak chaos. The judge gives her multiple chances to cooperate, represent herself properly, and move toward trial. But she keeps interrupting and making the same arguments again and again. Eventually, the judge warns that her behavior could cost her the right to represent herself. Then comes the ironic moment where she invokes her Fifth Amendment right to remain silent after talking nonstop for nearly the entire hearing.
The only thing I can do is, I'm not going to shout, okay?
I'm not asking you to shout. I'm just speak up a little. I couldn't hear anything back there at all.
All right. I'll do my best to accommodate you. All right, we've offered numerous times to give you the hearing aids.
I'm not going to put something that's not replaced in my ear.
Okay. Well,
you're not accommodating a handicapped person in this room. You can speak up a little bit because you have the rest of the times.
Okay. Thank you for so politely telling me how to do my job, Ms. Williams.
I'm just asking.
Appreciate that.
I mean,
that is wonderful.
I can't hear. If you want a successful hearing, you need to be able to let me hear it.
I need you to listen and don't interrupt me for a few minutes because I have some very important things that I need to go over with you about some of your conduct in court. Okay?
What conduct?
Listen and don't interrupt. Do you understand? Okay. You have exercised your right under Chapter 119 of Florida statutes 3 different times to obtain public records of this court proceeding. You did that on May 13th, 2025. You did that on June 6th, 2025, and you did that on July 15th, 2025. Each time that you made that request, in the process of making that request, you would have been required to go on the circuit's website and read the notices on that website about prohibitions of dissemination or publication of that information that you receive. When you received the recordings, it appears that you received them pretty promptly after the request. They were sent to you electronically by the court reporting services here in the circuit.
Yeah.
There's a very large banner circled in red, highlighted or bolded, that that says dissemination of this recording to any other person is strictly prohibited, except as permitted by law, rule, or court order. In that process, we are enforcing in this circuit Florida Supreme Court Administrative Order AOS or SC 1122 that requires that any audio or video recording that is released to a non-party shall be redacted of any confidential material. And this court, through its process of you requesting that information, has instructed you. I have not verbally instructed you. I'm about to do that now. But through your process of requesting these public records through our channels here, through our online service,
This final segment feels like the ultimate courtroom meltdown. The judge confronts her for posting court footage online, warns her about contempt charges, and explains how her behavior continues, making everything worse. She refuses to back down, argues about constitutional rights again, and even questions the judge about his oath. Somehow, the judge remains composed through all of it and delivers one final masterclass in patience. If you enjoyed this insane courtroom breakdown, make sure to like this video, subscribe to the channel, and we'll see you in the next video.